Hi everyone, welcome back to our video updates. I've been asked to cover some topics relating to collection defense since that is one of our practice areas. We do tend to do a lot more videos about the real estate topics because we get a lot of questions about real estate, and the real estate law is very, very complex compared to the collection world. So let me quickly go over this question that we received. This question that we received wants me to discuss what to expect whenever you're being sued by a creditor. So typically, at least in the state of Texas, I think it's similar in most states. Here in Texas, we don't allow people to sign something called a confession of judgment. We don't allow people to commit themselves to a judgment ahead of time, to give a creditor a promise that they will not object. So the creditors do have to go through a process to be able to get a judgment from the court before they can then try to do further collections. But what happens before the lawsuit is even filed? So let's say I take out a credit card and I use the credit card, but I'm not able to make the payments when they come due. And after a while, the creditor is going to charge that off. They're going to write it off as uncollectible debt. But before they do that, they will send me several notices. They'll call me and try to get me to pay. And if I still don't make the payments, they will finally send me a notice of default, which is a little bit different in the sense that the first few letters are collection notices, and then the final notice of default might come from a law firm letting you know that the file was assigned to that law firm. Sometimes it just comes from a collection company. And when you get that notice, it's going to tell you that you have 30 days to dispute the debt. You have 30 days to dispute the debt and ask for some sort of validation. So people are used to this because they can Google, and Google tells you a lot of things. But sometimes it's different in practice when you're actually having to defend yourself. So you will be able to challenge the debt. You could challenge the nature of the debt, or you could challenge the amount stated in the letter. So you could do either or. And of course, if you're in bankruptcy already, you would notify the creditor to let them know I'm in bankruptcy, and then they would have to stop contacting you and just monitor the case in bankruptcy court. And that's because bankruptcy law provides an automatic stay from all collection activity. So they'll have to go to the court to get permission to continue to pursue that debt if somebody is already in bankruptcy. And then once they file that notice that tells you that there's a default, if you dispute the debt, then they'll provide documentation to try to prove the debt to you, whatever that looks like. But ultimately, the creditor will then file a lawsuit if it's not resolved. Not all creditors sue for debt. Some do and some don't. And some of them just sell the debt off to a different company. And a lot of the times, if the debt is a small amount, they might not even pursue it at all. So typically, if it's less than $2,000, it's very rare. But if it's less than $2,000, they might still pursue it if it's a creditor that purchased the debt for very little. And so they might file a lawsuit in the lowest court, which is the most informal level of court. Here we call them the justice courts or the small claims courts. So those ones have a limit of $10,000 for all of the amounts claimed, including attorney's fees, court costs, everything. So the amount is going to change actually this year. The amount actually just changed in September of this year to be a higher amount. So the maximum now is $20,000. So they might file in a small claims court or justice court for smaller amounts because it's easier for them to navigate those courts as well. They don't have to do as much work as far as the law firms would go to be able to pursue that case. If the amount is a larger amount, of course, they can also file the lawsuit in a different court. So they might file in a higher court. Sometimes it's going to be the county court, and sometimes it's going to be the district court. And the only reason why I'm mentioning this is that some people think if the debt amount is very small, that the creditor is never going to come after them. So that's not true, but it's less likely that they will come after you. But a collection company that purchased the debt might be able to come after you. And then the other reason why I'm mentioning the different courts is that your response time when the lawsuit is filed, it varies depending on in which court the lawsuit was filed. So sometimes you'll have 14 days to respond, and sometimes you have 20 days to respond to the lawsuit. So that's for the collection lawsuits. And the document that you're served with will tell you the amount of days that you have on the citation itself. So the citations might be served on you using a constable, which is not very pleasant, but sometimes that happens. And then sometimes it might be served on you by certified mail, or other private process server might come to your house trying to find you. And sometimes they'll go to your business to try to find you. So it really depends on the facts of the case. So that's the main process. Once they file the lawsuit and you do get served, you have to get served. If they're not able to find you, they will still get you served. So people have this understanding or this misconception that if they're not able to actually serve you physically with the court papers or send the papers to you or somewhere as somehow get you the documents, that the case cannot move forward. And that's actually not true, because the lawyer that's working for the creditor or the collection company, the lawyer would then have to just jump through a few hoops to be able to get what we call substituted service or alternative service. So they'll change up the procedure to be able to get you served. It could be that they might have to give the documents to somebody that lives at your last known address, that's a relative of yours, or that they might have to post it on the door, which is not very cool because your neighbors might actually see that kind of stuff. They might post it on the door at the last known address if they're able to prove up that they believe that you live there and you're just evading service. Or they might be able to publish it in the local newspapers for a certain amount of time. Once all of those things are satisfied, depending on what the judge agrees to, then you're considered fully served. So it doesn't really matter that you avoided service. It doesn't really matter that the mail never got to you. If they can prove that they followed all the steps and made best efforts to serve you, they will probably be able to move forward with the lawsuit and get a judgment against you. The disadvantage to not participating in the lawsuit is that they might be able to get a default judgment. Once you're served and you don't make any appearance in the case, meaning that you don't file an answer and you otherwise don't show up at all to participate in the lawsuit to defend yourself, then the other side has an easier time of setting up a hearing, or even avoiding a hearing altogether and just submitting a motion for default judgment based on the case file itself. So if you're absent or an absentee defendant, then it's so much easier for them to get a judgment against you. So we always say, if you are getting notices on your door, you're getting phone calls from process servers, it's not very wise to avoid them indefinitely. Even if you avoid them at first because you're nervous about the whole thing, ultimately you do want to at least look and see what the call was about. You need to follow up to see what they're trying to serve you with, so that you can get some consultation with a lawyer that's appropriate. So those are the steps. So you get the notice of default. They don't notify you that they're about to sue you per se. They sort of threaten it in there, but they don't have to tell you anything additional to warn you before they file the lawsuit, as long as they follow those initial notices, those initial requirements for notices of default. And then after that, you will be able to defend yourself once you get sued if you are actually showing up to participate in that case. And you must file your answer within the time frame that's mentioned in your court documents, it's best to do that. If you've already missed the deadline, we still want you to go ahead and file the answer, because the judges would likely permit you to do that. So file the answer regardless, even if you don't know exactly all of the reasons why you should win the case. You should at least file a generic denial, which is probably what you've heard about already, and then you can get help to file an amendment to further defend yourself. And typically these cases will go on for months and months and months, and sometimes they drag on for a year or two. There might be discovery inside the documents that you receive. So discovery requests, these are requests for documents or for information. And so if you see anything inside the documents talking about discovery requests, you should also respond to those. Those are in addition to the general petition itself, and those require some responses, and they're supposed to be responded to within a certain time frame, which will be specified in the documents. It's typically 50 days from the time that you were served with a petition. So you would have to keep an eye out for that. If they don't serve you those requests at the beginning, but they serve you the request later on, then the time frame to respond is 30 days in Texas. So those are the things to pay attention to. You always have a chance to defend yourself, and you should always have a chance to do the debt validation. Even if you miss that 30-day time frame and you're now in court, you could still go ahead and request documents from the other side as well. So you can do your own discovery requests and ask for the debt validation at that point. And then of course that will determine whether the case will go forward, whatever happens in between. Some of them will go to mediation if it's a huge amount of money involved, and especially the medical bills and medical facilities. And then also some of them would go to settlement because you're able to reach an agreement with the other side. And we always suggest that you start very low when you're making the settlement offers, and make sure to get a payment plan that's convenient for you, because they have the power to do that if you press for it. So in general, 20% is a good place to start, 20% of the overall amount that they're asking for. And you could always ask for them to drop the attorney's fees and drop the court costs that they've requested as well. And make sure you get everything in writing once you do have a settlement agreement before you make any payments. And of course, you want to make sure that there's an agreement as to whether the lawsuit is going to be dismissed once you make your final payment. So that should be in there. And then you can always also use that final dismissal document to fix your credit reports if the item is already showing on there. So you absolutely want to avoid a judgment. It's really, really bad looking at your credit report, and it affects you when you're trying to get credit for the bigger purchases, especially if you're trying to get a mortgage or things like that. So that's our overview of the collection process. Hopefully this has been helpful to you. We'll do more videos regarding how creditors work, and what kinds of tools they use to come after people, and how you can protect yourself. We'll do more videos in the future on this channel, so be on the lookout. And if you like what you've seen so far, remember to subscribe, and definitely give us the likes if you like the videos. Thank you, and I'll talk to you next time.